Merci, Monsieur le Président.
Thank you, Mr. President. Mr. President, France would like, first of all, to congratulate you on your election to the presidency of this court. Mr. President, members of the court, my presence before you forms part of the continuing efforts made by my country in order to put an end to the dire humanitarian situation in the Gaza Strip and more generally throughout the occupied Palestinian territory. France deplores the considerable difficulties in accessing reliable information owing to the serious attacks against an increasing number of journalists. That being so, the information which Dutch reaches from Gaza is alarming. On the 24th of April, according to the figures of the Gaza Health Ministry, the human toll of the war amounted to over 51,300 deaths and 117,000 wounded. We must also mention the total interruption of humanitarian aid since the 2nd of March, the depletion of essential items, including food stocks, as well as the violent military operations carried out, many of which affect civilians and humanitarian workers. With regard to humanitarian workers, 418 of them have been killed since October 2023, including 290 personnel from the UN Relief and Works Agency for the Palestinian Refugees in the Near East, UNRWA, or the agency. In response to this situation that France will never cease to condemn, our position will remain firm and unwavering. Humanitarian aid must reach Gaza at scale. Restrictions to its access must be lifted without delay. All the crossing points must be open, and the work of humanitarian organizations must be facilitated and their personnel protected in compliance with international law. It is against this backdrop of emergency that the present proceeding take place, and which will enable the court to clarify Israel's obligations in relation to the humanitarian presence and activities in the occupied Palestinian territory, and in relation to it in support of the right of the Palestinian people to self-determination. The question put to the court calls for 4 introductory remarks. First of all, it deals with Israel's obligations. It will therefore fall to the court to precisely identify these obligations and the conditions of their observance. The question does not explicitly mention, as was the case for other requests for opinion, the legal consequences of a given behavior. However, the General Assembly, which requested the opinion and states, will have to draw all the relevant consequences from it. Secondly, the question put refers to the activities of other international organizations. Given the essential role of non-governmental organizations such as Médecins du Monde or Action contre la faim in the occupied Palestinian territory, France considers that their activities must also be taken into account in the present proceeding. However, in the time allocated and in view of the factual circumstances which gave rise to the sitting of the court, my statement will chiefly deal with the presence and activities of UNRWA. Thirdly, because of the expression in relation to the territorial scope of the question is not limited to the occupied Palestinian territory alone, this wording indeed invites the court to examine the international obligations that Israel must honor on its own territory insofar as their fulfillment is likely to have consequences throughout the occupied Palestinian territory. Finally, France has constantly recalled the importance of complying with the right to self-determination of the Palestinian people. The only chance for it to be exercised, according to France, is a two-state solution, the only solution capable of guaranteeing peace and security in the long term for Israelis and Palestinians. As my country has already underlined, supplying humanitarian aid and development aid will allow for the necessary conditions for the Palestinian people in the long run to be able to exercise its right to self-determination. This aid, therefore, is part and parcel of the exercise of the right for Palestinians for their self-determination. Mr. President, members of the Court, in light of these introductory remarks, my argument will successively describe Israel's obligations, which stem from its quality as a member state of the United Nations, and then those stemming from its quality of occupying power in the occupied Palestinian territory. It is important to underline that these obligations are not mutually exclusive. On the contrary, they are simultaneously applicable and complement each other. With regard to the obligations arising from United Nations law, I will begin by addressing the general obligations of Israel in relation to the presence and activities of UNRWA in the occupied Palestinian territory and in relation to it, and then more specifically, the privileges, immunities and facilities owed to the agency as a UN organization. First of all, it should be recalled that, as for any subsidiary body of the General Assembly of the United Nations, the presence and activities of UNRWA on a given territory are subject to the consent of the parties concerned. Israel and UNRWA have concluded several agreements, including an agreement concerning assistance to Palestinian refugees, which entered into force on the 14th of June 1967, which I will hereafter call the 1967 agreement. This agreement governs the activities of UNRWA in the occupied Palestinian territory, but also activities in relation to it. Some of its provisions indeed refer to the entry of vehicles and personnel of the agency into Israel. The Palestinian Authority has also reached a number of agreements with UNRWA, including an agreement relating to the location of its headquarters in the West Bank and in the Gaza Strip, signed in Ramallah on the 5th of July 1996. On the 28th of October 2024, Knesset adopted two laws aiming at prohibiting the activities of the agency in Israel and through a questionable extension of its domestic law throughout the occupied Palestinian territory. This legislation, amongst others, has given rise to a notification addressed to UNRWA on the 3rd of November 2024, in which Israel deems it has terminated the 1967 agreement. In France's view, the general principle of the consent of the parties concerned by UNRWA's activities must apply in combination with Israel's other international obligations in the occupied Palestinian territory on the one hand and on its own territory on the other hand. I'll deal with both of these aspects successively because the combination is not identical in both situations. First of all, in the occupied Palestinian territory. As a member of the United Nations, Israel's margin of appreciation in banning UNRWA's activities are, first of all, qualified by its general obligation to cooperate in good faith with the UN. This obligation in particular stems from Article 2, Paragraph 5 of the Charter, which provides that the members shall give the United Nations every assistance in any action it takes in accordance with the present Charter. As underlined in the chapeau, the implementation of this provision is a prerequisite for the achievement of the aims of the United Nations laid down in Article 1 of the Charter. In this connection, it should be recalled that the UN's objectives, inter alia, is that of achieving international cooperation in solving international problems of a humanitarian character. The Court has long held a broad interpretation of the duty of assistance of member states by applying it also to the actions of the General Assembly, although there is no suggestion that the legal consequence of this duty is to confer a binding force on its recommendations. Furthermore, Israel's obligation to cooperate with the UN in the specific framework of humanitarian assistance in Gaza has been recalled on several occasions by the United Nations bodies. For example, in its order indicating provisional measures of the 28th of March 2024, which is still producing effect to this day, your court ordered Israel to take all necessary and effective measures to ensure, without delay, in full cooperation with the United Nations, the unhindered provisions at scale by all concerned of urgently needed basic services. Israel, therefore, is under an obligation to provide full assistance to the action of the agency in the occupied Palestinian territory, which implies, as a minimum, the obligation not to impede its activities. Turning now to the territory of Israel proper. The obligations of Israel vis-à-vis UNRWA in the occupied Palestinian territory must be distinguished from those concerning the presence of the agency on the Israeli territory as such. In its advisory opinion relating to the headquarters of the WHO in Egypt, the court has recognized the sovereign power of decision of a state when it comes to the presence of a UN agency on its territory. The withdrawal of consent of a state to this presence stems from the same sovereign power of decision. Having said this, this power is governed by the obligations owed to the UN by a member state in the case of a denunciation of the agreement relating to the presence of a UN agency on its territory. These obligations have been described in detail by the court in its aforementioned opinion. And this opinion is very well, may very well be transposed to the instant case, in part because the 1976 agreement says nothing of the modalities for denouncing it. Pursuant to these obligations, Israel and UNRWA must first of all negotiate in good faith the conditions for transferring the agency's activities outside the Israeli territory. Israel must also allow the agency a reasonable notice period to prepare for its departure, and finally grant it and grant its personnel the privileges, immunities and facilities necessary for a smooth transitional period. Furthermore, the exercise by Israel of its power of withdrawing its consent to the presence of UNRWA on its own territory means that it must take into account the consequences of such a decision on the occupied Palestinian territory. This decision indeed has consequences in relation to the occupied Palestinian territory within the meaning of the question put to the court. Many of UNRWA's activities in the occupied Palestinian territory are conditional on facilities or authorizations issued by Israel on its own territory, including for any transit to or from the occupied Palestinian territory. Doing away with these facilities could concretely and lastingly impede physical access to the occupied Palestinian territory and therefore impede UNRWA's ability to operate there. Such consequences would obviously be incompatible with Israel's obligation not to impede the actions of the agency on the occupied Palestinian territory, as previously discussed. This obligation must therefore equally be considered as qualifying the sovereign power of decision of Israel in relation to the presence and activities of UNRWA on its territory.
I would now like to turn to the obligation to respect the privileges and immunities and the facilities of UNRWA. Article 105 of the UN Charter and the Convention on the Privileges and Immunities of the United Nations, which I will call General Convention, specifies the privileges, immunities and facilities that Israel must afford to the United Nations and its staff. It should be noted that the scope of the convention, this General Convention, was explicitly extended to the occupied Palestinian territory by the 1967 agreement. However, even if this agreement were considered to have been duly denounced, the General Convention would still remain applicable to UNRWA both in Israel and in the occupied Palestinian territory. Indeed, if Article 105 of the Charter refers to the territory of each of its members, the provisions of the General Convention, commonly regarded as an amplification of Article 105, are drafted in particularly open terms. They refer, for example, to UN property and assets wherever located and by whomsoever held. This is in Section 3. The object and purpose of the General Convention is to protect the assets of and the agents of UN with a view to enabling them to exercise their missions for which these members have been mandated. Therefore, it would be indeed paradoxical and even contrary to the object and the purpose of the Convention to deprive the organization of any form of protection on the grounds that it is acting in occupied territory, whereas it is a territory over which it has a particular responsibility itself. Consequently, Israel is obliged to apply the General Convention in the territory that it occupies, even in the absence of a special agreement to that effect. I will now address successively Israel's obligations under international humanitarian law and then under international human rights law. As far as international humanitarian law is concerned, France underscores to begin with that Israel, just like other states, has the obligation to respect and ensure respect of the Geneva Conventions under all circumstances. Furthermore, as the court recalled in its opinion of July 2024, neither the duration nor the unlawfulness of Israel's occupation in Palestine results in releasing the occupying power from its obligation in this respect. So in this context, I will limit my comments to detailing two obligations. The first of these obligations is to ensure and to facilitate unhindered supply of basic necessities that are essential to the survival of the civilian population. This obligation originates in Article 59 of the Fourth Geneva Convention, to which Israel is a party, and which applies to the whole of the occupied Palestinian territory, including Gaza, as your court recalled in its opinion last July. The question of the application of this provision arises with extreme gravity at the very moment when the current hearings are taking place. In Gaza, the entry of trucks delivering humanitarian assistance has been totally suspended since the 2nd of March. International organizations that are still present are warning us about the depletion of food stocks and multiple shortages of medicine. It should be noted that even in the West Bank, the increasing number of controls is hampering the intervention of human organizations on a daily basis. Article 59 imposes on the occupying power two obligations that it cannot be released from if it is established that all or part of the population of the occupied territory is inadequately supplied. In this case, the occupying power must, on the one hand, accept humanitarian assistance, because this is a performance obligation. Therefore, the occupying power must not refuse any humanitarian assistance. On the other hand, the occupying power shall facilitate the relief schemes by all the means at its disposal. And by virtue of this obligation of conduct, the occupying power must, in good faith, use all means available to facilitate the delivery of aid that it has accepted. Article 59 is worded in such a way that it covers both collective relief provided by states and the aid provided by impartial humanitarian organizations. However, it does not provide any restrictive list of relevant organizations in this context. In principle, an occupying power therefore has a margin of discretion in the choice of organizations capable of providing the necessary aid. In practice, however, the occupying power is obliged to take into account the specific circumstances of the territories that it occupies in order to authorize and to facilitate the activities of adequate humanitarian organizations. That is to say, those that are genuinely capable of providing sufficient aid to supply the local population. Finally, it should be emphasized that Article 59 contains a safeguard clause allowing notably the occupying power to search the consignments and to regulate their passage according to prescribed times and routes. While controls may be justified under this clause, France would like to recall that they cannot lead to preventing humanitarian assistance because that would render Article 59 devoid of substance. In the present case, it should be borne in mind that UNRWA is indeed the main provider of humanitarian assistance and essential services in the occupied Palestinian territory. Furthermore, France notes that to benefit from these provisions, UNRWA must be an impartial body within the meaning of Article 59. And in this context, France has noted the conclusions of the Colonna report on UNRWA's adherence to the principle of neutrality. It stresses that the agency is committed to implementing and continuing to apply a zero-tolerance policy in this regard. These circumstances, coupled with the catastrophic current situation, reduces significantly Israel's margins of discretion in executing its obligation under Article 59. Indeed, in the absence of other actors with sufficient capacity to provide adequate supplies effectively to the population, Israel is obliged, as occupying power, as long as the situation persists, to authorize and facilitate UNRWA's relief schemes in the occupied Palestinian territory. Israel's second obligation as an occupying power is to protect humanitarian workers. Indeed, for humanitarian aid to be effectively delivered to civilians, the safety of staff working for the organizations providing that aid must be ensured on the ground. And parties to the conflict must conduct hostilities with this protection in mind. In this respect, the obligation to protect humanitarian workers can be considered as a corollary of the right of the civilian population to be rescued. Under customary international law, the rule according to which humanitarian relief personnel must be respected and protected is also regularly recalled by the Security Council. This reminder seems all the more necessary given that, according to the UN Office for the Coordination of Humanitarian Affairs, on the 22nd of April 2025, at least 418 humanitarian workers have been killed in the Gaza Strip since the outbreak of the war in October 2023. In this context, France reiterates its condemnation of Israeli firing on ambulances that killed rescue workers, 15 rescue workers from the Palestinian Red Crescent, the Civil Defense, and UNRWA in Gaza on 23rd of March 2025. I would now like to turn to Israel's obligation to respect international human rights law in the occupied Palestinian territory. As the court has had the occasion to indicate, Israel's obligations derive, among others, from the two covenants of 1966, as well as from the UN Convention on the Rights of the Child. Moreover, the court has already recalled that the protection offered by human rights conventions does not cease in case of armed conflict or of occupation. Indeed, Israel's obligation to provide humanitarian access under international humanitarian law is supplemented by various other obligations under international human rights law. And in view of the serious and imminent risk of famine that Palestinian civilians in Gaza are facing, I would also like to emphasize the right to health and the right to adequate food. In accordance with Article 2 of Paragraph 1 of ICESCR, each state party undertakes, individually and through international assistance and cooperation, with a view to achieving progressively the full realization of the rights recognized in the present covenant by all appropriate means. Consequently, if human assistance is in a given situation indispensable to the realization of the two aforementioned rights, a state must consider this aid as a means that is appropriate to their realization within the meaning of this provision. In view of the untenable situation in which the Palestinian civilian population finds itself, there can be no doubt that humanitarian assistance can be qualified as a measure that is conducive to Israel's implementation of its obligation under ICESCR. Moreover, since such aid would be essential to the enjoyment by the Palestinians of their fundamental rights, Israel could not restrict access to it without violating the aforementioned obligation. Mr. President, members of the court, it follows from all these elements that Israel is under the obligation, given the critical humanitarian situation in the Gaza Strip, it is under the obligation to authorize and to facilitate the presence and activities of humanitarian actors there, in particular those of UNRWA. To conclude, France reiterates its appeal to the Israeli authorities to put an end to the dramatic humanitarian situation in Gaza, and to this end, it calls on Israel to cooperate with its international partners, including the United Nations, to ensure, as a matter of urgency, access and security for humanitarian operations in the Gaza Strip and the whole of the occupied territory. Thank you very much.